For a long time it was unclear whether there would be a hard Brexit, a final withdrawal of the United Kingdom from the EU without a trade agreement. At the very last minute, on Christmas Eve, the UK-EU Trade and Cooperation Agreement was born. The agreement covers numerous matters that were previously regulated at European level, such as judicial cooperation in criminal matters. On the other hand, it is silent on cooperation in civil matters. That means on questions of international private law and international civil procedure law. Despite the tough negotiations, this is a surprising result, precisely because this area was strongly standardized across Europe. What exactly does this mean for cross-border legal relationships under civil law? Has there been a lawless area since January 1st? Can companies and private individuals still sue across borders? Where and how can you do it, and where and how should you do it? One thing is certain, there is no such thing as a lawless area. Cross-border civil action can still be brought. The abolition of the European legal framework for civil matters will make the procedures more expensive, cumbersome and lengthy. The legal situation has become more complex and complicated. What was a unified legal area in the sector of international private law and international civil procedure law is now a fragmented patchwork of regulations at different levels. With Brexit, the United Kingdom has primarily taken a decision against the regulations on international civil procedures law, known as the Brussels regime, which until now have comprehensively coordinated European civil procedural law. In particular, the Brussels regulation on jurisdiction and the recognition and enforcement of judgments in civil and commercial matters was of vital importance in this area. The acquis of European civil procedure law continued to include the previously applicable regulations on the dunning procedure, the taking of evidence, service, handling of enforcement titles, and attachment of costs. The Brussels regulation on jurisdiction and the recognition and enforcement of judgments in matrimonial matters and in proceedings relating to parental responsibility was particularly important for private individuals. The trade agreement of December 24th does not contain any provisions on international civil procedure law or international private law. Even if the primary regulations under European law want to take into account the future relations of the exiting state with the Union, a legally secure solution is therefore not immediately in sight. However, it can already be predicted that the new legal situation will open up options for action in the area of strategic litigation. Procedural instruments from common law can, under certain circumstances, again be made fruitful. So-called torpedo lawsuits, which are intended to prevent the opponent from being sued, could be used more frequently again, as could anti-suit injunctions. That means anti-lawsuit orders in common law states in order to prevent proceedings in other states. The shopping forum, which has been pushed into the background by the Brussels system, should also become more relevant again. It is not without controversy, but with the effectiveness of Brexit, the United Kingdom is likely to fall back on the provisions of the Brussels Jurisdiction and Enforcement Conventions of 1968. This binds the courts in the United Kingdom on issues of international jurisdictions and enforceability, at least with regard to the older EU member states, which are also contracting states to the Convention. In relation to the other younger EU member states, the United Kingdom believes that its autonomous international civil procedural law remains applicable. Conversely, however, the courts of the younger EU member states will continue to apply the Brussels regulation after Brexit, at least insofar as the relevant jurisdiction is based on a connection point in one member state. For the older EU member states, on the other hand, recourse to the Brussels regulation is blocked by international law. The coexistence of these regimes is likely to be a challenge for the courts and lead to legal uncertainty. In addition, there is another aspect that is likely to be a thorn in the side of the Brexiteers in particular. The recognition and enforcement of a decision of a judgment from an EU member state are based on the provision of the Brussels Convention. They can be denied if they are subject to public policy from the national law of the executing state, for example, the United Kingdom. The issuing of the enforcement clause is also based on the national law of the executing state. This can of course be changed by the competent national legislative body, in the case of the United Kingdom, the British House of Commons, but ultimately the compatibility of national law with the interpretation of the Convention is judged by the ECJ on the basis of the determination of jurisdiction in the Supplementary Protocol of 1971. By the institutions, the UK could not finally free itself from the EU. A feasible way of creating legal certainty in international civil procedural law would be the independent accession of the United Kingdom to the Lugano Convention of 1988 on jurisdiction and the enforcement of judicial decisions in civil and commercial matters, a parallel agreement to the Brussels Convention. The convention was reformed 2007 and largely aligned with the Brussels regulation. It currently applies between the EU member states, Switzerland, Iceland and Norway. The United Kingdom submitted an independent application to join in April 2020. However, since accession to the Lugano regime requires the consent of all contracting parties, including the EU, and depends on the political will of the actors involved, it remains to be seen whether the United Kingdom can really join in view of the swingback. And you must not forget, all the members there are either EU members or members of the European Economic Zone and very closely aligned to the EU. The UK is not. The UK could also join the 2005 Hague Convention on Jurisdiction Agreements. However, the convention is only applicable to exclusive choice of court agreements between companies. The UK's economic policy interest in joining is likely to be high, which is why it filed a declaration of membership in September 2020. For private individuals, the respective national law applies again in the area of family and inheritance law, unless the Hague Convention of 1970 or the Hague Maintenance Convention of 2007 apply. In consumer protection, the national provisions apply, which in the United Kingdom currently still reflect the consumer protection requirements of the EU. With regard to online trade, which is so important for consumers, this means that the purchase of goods or services in a UK online shop that does not conduct its business across borders and is based in the UK should be judged under UK law. In the case of a British online shop with a cross-border orientation, however, German law remains applicable to a German consumer, and French law to a French consumer. Choose whatever you like. In case of doubt for the arbitration agreement, the Brexit will result in significant changes and many uncertainties in the area of international private law and international civil procedure law. The strategic conduct of proceedings using the now important national procedural law instruments on both sides of the English Channel is becoming more complex. For companies that can rely on lawyers with expertise, this will not become an insoluble problem. For private individuals and consumers, however, these challenges are more difficult to master. At least in corporate transactions, international arbitration law is likely to offer itself increasingly as a viable alternative. Arbitration awards are recognized on the basis of the New York Convention from 1958, which remains completely unaffected by the hard Brexit in the area of international private law and international civil procedure law. The conclusion of an arbitration agreement is therefore a safe choice. And if you want to stay informed, please subscribe to my channel and my other channels. I'll see you in my next video. Bis gleich.